The context of this discussion is that students were assigned a relatively complicated case study that involved a U.S. manufacturing company, ABC, setting up manufacturing facilities in two countries that would be chosen by each student. The new facilities would locally manufacture food products currently being manufactured by ABC only in the U.S. Most of the discussion in this session assumed a manufacturing facility operated within a Thai subsidiary of ABC, termed EXCO. The facts provided to the students assumed three types of personnel movements. First, various ABC U.S. personnel temporarily working in Thailand for varying short-term lengths of time during the 18-month construction period of the manufacturing facility. Second, certain ex-company Thai employees training in the U.S. for 9 months. Third, 5 ABC U.S. management level executives transferred to Thailand for 3 years to run the manufacturing facility and its business. These personnel movements raise various individual and corporate tax issues. This roughly 45-minute discussion covers some of these issues, including discussion of both domestic law and tax treaty matters.
If the movement of employees is an interesting area to you, this is a very good case study to look at some of the things that affect the movement of people. If I remember correctly, let's say, as you say, this is Thailand, and this is the U.S. up here, here's ABC, and let's say that you have separately suggested that there be a Thai subsidiary which will operate the manufacturing facility and produce cereal and bars. And the facts tell you several things about employees. One of them was that there will be 5 management people that are going to be on the ground in Thailand for 3 years. So number one, in a sense, is the 5 management people. 2 is that there's a construction period. There's going to be, I think it was an 18-month construction period, and there will be some number of people from ABC who will travel to help with the construction of the facility, maybe supervision. They will help with the layout and installation of the machinery. They will do things like that. So we have as number 2 what I'll call the short-term people during construction. And then 3, you have some training back in the United States of some of the people down here at, let's call it X, so that X employees training less. With each one of these, you have issues that are both individual issues and potentially corporate issues. Taking these 5 people, taking them first, although I guess in time we should be 1, 2, 3, but yeah, let's change it so that we're consistent with timing. In other words, this is going to be 1, short-term people coming over construction. 2 would be X's employees getting trained some, and then 3, the management people who are going to be in Thailand for 3 years. and potentially more if they decide to stay longer in the company. From the individual standpoint, as opposed to the corporate standpoint, if we look at the short-term people, they come over, and we're assuming that, for simplicity, we're assuming they're all U.S. people. ABC has pretty much all its operations in the United States. That's the facts you're given. If there were, if you were doing work for another company that had operations in many countries, then maybe the people would come from, third countries, from Germany or from, could be from any country. But in this case, for simplicity, they're all coming from the United States. One thing that you could choose to look at or not look at is not a tax issue, but in a sense, an immigration issue, which is, do we have any problem getting these people into the country to do this work? It may be easy. No, I don't know. I've been to Thailand a few times for business meetings, and they just let me in, and then I leave. But if I were going to work for 3 months on a project, I don't know whether they would allow me through the border easily, or whether I have to do something up front to get permission to come in to work for 3 months. So there's an immigration issue. And this is part of the broad area in which what we are calling international taxation, this is a real issue. Now, maybe another lawyer takes care of it, or maybe you take care of it. But this is part of the broad area that we work with. So if you're interested in that area, fine, take a look and see, is there any problem with getting the people in to do the work? You're right, it's not a tax issue, but it is an issue that somebody will have to look at. Now, I'm not saying that you have to look at this immigration issue for your countries. If you want to, you can look at it. But if you do not want to, you might just mention in one line that we would need to, this is an issue, and we would need to talk with, the client will need to retain local counsel to get information on whether there's any difficulty and what procedures are necessary to physically allow the people in for the short-term periods that they will work. A good question. What were the facts that were stated? Anybody remember? Yes, some management people who are going to supervise the construction, but the general construction workers, of course, will be hired locally. So there's going to be local construction workers, there's going to be some people sent over who are either management or who are maybe specialists in certain areas. For example, the installation of the machinery, the layout of the plant. All of these things need attention of people who are coming from here. Now, to the extent that, yes, they can find people in Thailand to do this work, fine. Obviously, they'll want to do that. It's cheaper than sending somebody from the United States. But there will be some number of people, whether it's 3 or 4 or whether it's 25. And I don't remember, I don't think we gave specifics in the facts of how many people, that sort of thing, and how long each would be. But we did say that there would be some number of people, I think over a period of 18 months of the construction work, and they would be providing the necessary services to allow X to have a facility that is up and running and capable of making cereal and bars. We need to look at these people who are here for, let's say, 3 months or 7 months or whatever it is for this period, how will they be treated by Thailand? Does the domestic Thai law, how does the domestic Thai law define resident individual and non-resident individual? Because I don't know, if Thai law has a roughly a 6-month or 183-day rule, like a lot of countries do, if somebody comes over and spends more than 183 days, then maybe he's a resident. And typically, if he is a resident, domestic Thai law would tax him probably on a worldwide basis for his period of residency. And maybe, I don't know what, again, the tax rate is on an individual, but it's probably pretty high. That's an issue. Do the individuals become residents? If they are, then what applies to them? Now, maybe you'll find that one of your recommendations will be, it's a terrible tax answer if any of them become resident. And therefore, to the extent they can in their planning of the work, try not to have the same person here for more than 183 days. Now, maybe ABC will say, God, this guy is so important, he has to be there, we will bear the cost. But if they have flexibility, maybe they have 2 or 3 people who can do this job, then over the 18-month period, maybe they could use 3 different people. So again, this would be a planning point where you could recommend something to ABC. ABC might be able to do it. Maybe they can't. That's going to depend on their particular situation. But yes, you might recommend. Try to make sure that none of these people become resident. Now, let's assume that we have a person who is non-resident. Now, let's say he's just over for 3 months. And let's assume that Thai law says that if he's only there for 3 months on a temporary assignment with plans to return to his home country, that's a non-resident. Well, how will Thailand tax him? Will Thailand tax him under domestic Thai law? So that's a question. Very often there will be, as we talked about before, generally for non-residents, maybe a flat tax on income earned from services performed in Thailand. That's what I would expect to see, whether in fact that's what the Thai law says. Now the next question is, okay, you've determined how they're going to be taxed under domestic Thai law. There's a treaty between U.S. and Thailand. Now, here, the taxpayer is the individual. It's not the company. So we need to look at the tax treaty and decide, okay, how does the tax treaty affect this person? Let's say first we're talking about a guy who's here for 7 months, and let's say that domestic Thai law calls him a resident. He's always planning to go back to the U.S. This is a known short-term assignment. Now, you might look at that and say, well, gee, the guy's a dual resident. He's a resident of the U.S., but under the particular black and white 183-day rule in Thailand, he's a resident of Thailand. There's normally what's called a tiebreaker provision. And you normally find this in any treaty which follows the OECD or UN model conventions. You'll find this in Article 4. And essentially it says for an individual, different treaties can be slightly different, but roughly they're normally the same. The tiebreaker provision will look at the individual. If we look at Article 4, we will find paragraph 2, where an individual is a resident of both, then his status shall be determined as follows. Be deemed to be a resident only of the state in which he has a permanent home available to him. Now, in most of the cases of these temporary people, they probably will have a permanent home. He owns a house, which he maybe leaves his wife and family. Or maybe he's single and has an apartment. Well, gee, did he give up his apartment or did he retain his apartment, which is his home? These are factual questions. If he has a permanent home available in both countries, he shall be deemed to be a resident only of the state in which his personal and economic relations are closer. Okay, this really isn't him. He doesn't have a permanent home in China. If A does not apply, D is saying then he shall be deemed to be resident only where he has an habitual abode. What's an habitual abode? That's never been perfectly clear to me, but habitual abode. I've never seen a good definition of what habitual abode means, but I think generally, at least where I've seen the term used, it means where do you spend more time. So anyway, the point is there's a hierarchy. We'll talk about this again when we talk about treaties, but there's a tiebreaker provision. And you could say something about this for the people who are coming over, that if they are resident under Thai domestic law, the treaty under the tiebreaker provision would probably throw them back to only residency in the United States because that's where they have a permanent home. And now, since they are going to be treated as non-residents, how will Thailand tax them? Okay, well, can we just go to Thai law, or do we have to look back at the treaty? Okay, if we go to Article 15, the long and short is saying, okay, paragraph 1 is your general rule that if you have a resident of the U.S., an individual resident of the U.S., who is working in Thailand, physically in Thailand, then Thailand can tax it. That's the general rule. Paragraph 1. Paragraph 2, though, is providing an exception. If remuneration of a resident of the U.S. in respect of employment exercised in Thailand shall be taxable only in the U.S. if A, B, and C. That means that all three of those have to be met. First one is less than 183 days. Secondly, the remuneration is paid for or on behalf of an employer who's not a resident of Thailand. So the remuneration, let's say, is paid by ABC. So it means the person could meet A, person could meet B, but then C, the remuneration is not borne by a permanent establishment which the employer has in Thailand. So now we are pushed to a corporate question. We have to answer a corporate question in order to answer the individual question. ABC is going to have people involved in the construction for 18 months. Does ABC have a permanent establishment in Thailand? By virtue of the people and the activities that are going on in doing work for X. If we go back to Article 5, which is the definition of permanent establishment, we find that a building site, construction, or installation project constitutes a permanent establishment only if it lasts more than 12 months. Now, again, you have to look at the Chinese-U.S. treaty. Pike would look at the Thai-U.S. treaty. and see what it says. I've seen, if I remember correctly, the China-United Arab Emirates treaty provides, I think, 24 months. I mean, we have to look at the treaty, the relevant treaty, but at least based on the OECD model, we would say it looks like ABC probably has a permanent establishment from this activity. We're talking about individuals right now. But obviously, one of the areas for that you can include in the assignment 4 is something about the taxation of ABC for the work that it does in Thailand over that 18-month period. How will ABC be taxed by Thailand? So anyway, let's assume that we've decided that ABC does have a permanent establishment, all this activity over 18 months. Well, if we go back to Article 15, we don't meet Condition C because Condition C says the remuneration is not borne by a PE that the employer has in Thailand. And if the work that that individual is doing is obviously a very important part of this effort, then that would be an expense allocable to this activity of ABC in Thailand. Paragraph 1 is a general rule. Thailand has the right to tax an individual resident of the U.S., but only to the extent that the services are performed in Thailand. If the person performs work in Hong Kong or back in the United States, Thailand cannot tax that. And again, note that in Article 15, we've already made the decision that the individual is a resident of the U.S., he's a non-resident of Thailand. We've already made that decision. This Article 15 does not apply to anybody who is, under the treaty tiebreaker provision, a resident of Thailand. So when this individual comes and he's a non-resident under local Thai law, he's to be taxed in a certain manner as a non-resident, then you look to Article 15 of the treaty and you see whether paragraph 2 can exempt that individual from any Thai tax. And we've decided that this rule, paragraph 2, where you have to meet all of 3 conditions. The individual can meet the first condition, he can meet the second condition, but he fails the third condition because ABC does have a permanent establishment in Thailand. And because his work relates to the activities of that permanent establishment, he fails item C there. That's right. He has the honor of paying personal income tax to Thailand. No. The tiebreaker just determines whether the individual will be a resident or non-resident of Thailand for purposes of applying the treaty and generally Thai taxes. We have to go step by step with the language, and I'll try to, I hope at the end, show why it makes sense, and that there's some logic to this. Okay, the first one is the individual, resident of the United States, non-resident of Thailand. He is, the general rule, paragraph 1, Thailand can tax him, but only to the extent he does his services, his employment activities inside Thailand. Paragraph 2 gives an exception. The individual will be exempt from Thai tax if he meets these 3 tests. remuneration derived by a resident of the United States in respect of an employment exercised in Thailand shall be taxable only in the United States if the individual meets a 183-day test. 2, the individual receives his salary from an employer who is not a resident of Thailand. And that could be a U.S. company, it could be a Dutch company or a Chinese company. It doesn't have to be a U.S. company. It could be anyone. And then C, the remuneration is not borne by a permanent establishment which the employer has in Thailand. And we are saying that because of those 18 months worth of activities, we looked at the PE article, which is Article 5 normally, and we saw that to the extent that there's a 1 year or less test, with 18 months, ABC would have a PE. And his activities relate to what that PE is doing. So his remuneration would be part of the expense base of the PE. Now, the logic, well, if there's a PE, that it means that ABC, within that defined PE, will have income and expenses. And ABC will be taxed by Thailand on the net income of that permanent establishment. There's a certain symmetry. If there is a deduction for salary cost here against the corporate income of ABC, then Thailand wants to be able to tax the salary. It's deductible to the company paying the salary, and it's taxable to the individual. There's a symmetry. On the other hand, if ABC has no permanent establishment, does not fill out an ABC Thai tax return showing income and expenses, then that salary is never deducted against taxable Thai income. And from a symmetry standpoint, well, don't tax the individual. There's a bit of symmetry here. If the corporation deduction for salary is meaningful because that reduces Thai corporate tax, then hey, we should tax the individual. Symmetry, there's a logic to it. Now, let me say one other thing. When you're, and I'll say this again when we talk about tax treaties, when you read the language of the tax treaties, you will find that it works a lot better and you understand it much better if you put the name of the relevant country. Whereas instead of reading salary, wages, and remuneration derived by a resident of a contracting state and then the other contract, I mean, the stuff, you get lost very quickly. I get lost very quickly. So if you read it and you say, okay, a resident of the United States shall be taxable only in the United States unless the employment is exercised in Thailand, and if it's so exercised, in other words, in Thailand, then Thailand may tax it. So when you read these things, put in the name of a country and make sure that you're putting in the right name. This contracting state, the other contracting state, first mentioned contracting state. I mean, that's terrible language. But if you put in the names of the countries, then it starts to be easier to read. I'm using the model treaty just simply because I don't have handy the Thai-U.S. treaty. you should use, if there is a treaty, the actual treaty between the countries. Yeah, so if you're looking at something India, U.S., you should look at the India-U.S. treaty. We've determined at the end of the day that probably, again, you've got to look at this and do your research in the context of Thailand. But at the end of the day, you determine probably they are non-residents because of the tiebreaker provision in the treaty. But even if they are non-resident, they're still taxable in Thailand because the exception does not apply in Article 15. So the individuals end up being taxed. The individuals, of course, as U.S. residents, are taxed on worldwide income, and they get a foreign tax credit for the Thai tax. Now, an interesting question will be, if the U.S. tax rate is only, let's say on average, for these people, somewhere maybe 25%, on average because of the brackets and so on. If the average tax rate on an individual is only 25%, but down in Thailand here, they're being taxed 40%, 30%, whatever the figure is, then maybe there will be some excess foreign tax credits on these individuals. And they will be paying, in terms of total United States and Thai tax, more than they would have paid back in the home country. Now, if your employer told you to go do a job in another country, and as a result, you were taxed more than you would have if you just stayed and did your job in your home country, would you complain to your employer?
I would tell them to repay.
Yeah. So this is a real issue. That yes, very often employers will pay that. And not only will they pay the amount of tax, but employers very often will pay for the local tax preparation. In other words, pay an accountant in Thailand for the local tax preparation of the individual tax return, and possibly even the U.S. return, because the damn thing is so complicated. So this is a major business area of the accounting firms. And their advice is a combination of tax issues and human resource issues. You are brilliant. You're absolutely right. Typically, if the employer pays the taxes, it's just like any other situation where an employer pays my personal obligation for me. That's income to me. And you get into a spiral that's called tax on tax. When we're talking about, now let's jump over to the 5 management people. They're going to be here for 3 years. Think they bring their family along? Yeah, they bring along their, their wife and their dog or cat, maybe a few children. When I went to Hong Kong the first time, I brought along a pussycat. The company paid for it. The shipment of the pussycat.
Oh.
And the company also paid for 6 months of quarantine for the cat in Hong Kong. People who own the quarantine facilities, have undue political power in Hong Kong, so the quarantine period was 6 months. Most other places, it's like 1 month or less. The point is that when somebody goes overseas for a few years and carts his family along, very often the employer will have a personnel policy for expatriate employees that covers all sorts of things. Are there local schools in English? Probably not. So maybe the kids have to go to an international school where they teach in English. That's $25,000 a year per kid, or whatever. Expatriate and his family are being asked to spend, 3 years in Thailand. gee, should we give them plane tickets to come back to the United States to see their relatives and so on? Well, there's a home leave benefit that is sometimes given. These guys who go over, they have a house. Well, is the house going to be vacant? Is the house going to be rented out? Sometimes there can be allowances to maintain the house in some way. Or if the person sells the house at a loss, maybe the company will even make up the loss. There can be all sorts of crazy things. It depends on the company and depends on the policies that it has. Pike, you've probably been to the store here, and you see how much a steak is. Would that same piece of meat be more expensive or less expensive in Thailand? And further, the average Thai person doesn't eat a 16-ounce steak. It's brought in for the few people who have enough money to want to pay for it. And when people from the U.S. go to another country, there's sort of an assumption that we're going to give you an allowance, a cost of living allowance, to allow you to live in, let's say, some reasonable fashion which somewhat equates to what you had back in your home country. So that's called a cost of living allowance. You think it was bad in Thailand. In Japan, of course, the cost of a steak can be above the ceiling. And the cost of living allowance was very high. Fortunately for me, my wife and I were happy with ramen, Japanese noodles. So we ended up being economically much better off for being in Japan because the cost of living allowance was very high. When I was in Russia, Thailand is not, Thailand's a nice civilized place. When I was in Russia, that was considered a hardship post. So there was an extra amount that the company paid to give me to make up for the hardship of being in Russia. The point is, again, in your terms of your question, the amounts that people are paid are far, far more than their base salary and bonus. If some of those items, the cost of housing, if your apartment that you have here in Seattle, Pike, how much would a similar apartment cost in Thailand? Or less? You think less? Okay. How about if it were a big, fancy apartment? That's totally ridiculous. Yeah. So the cost of housing, again, when you've got a high-level executive going with his wife and his dog and his 3 children, the cost of housing can be astronomical. So again, all of these things, to some extent, will get into the taxable income in Thailand and, of course, are also taxable income in the United States. And then to the extent the employer reimburses the employee for all these extra taxes, above what he would have had back in the home country, it's just astronomical. I mean, you can have the total employment cost be 2 or 3 times the base salary and bonus. The numbers get very big. Okay, you're talking about Section 911. And Section 911, I won't say it is worthless. It's been an absolutely, again, wonderful thing for the accounting firms that prepare Form 1040s for expatriates. But the amount of benefit from it has been whittled down over the years. When I first went overseas, it was a major benefit. But there have been changes to it over the past 30 or 40 years that literally made it so bad that when I was in China for 2 years in 2006 and 2008, I specifically did not claim it on tax return. There is in Section 911 an exemption. So let's say that a guy has actual housing cost of $50,000 in Thailand, but the at-home amount under the rules in 911 would be $30,000. So the $20,000 difference, you can reduce your taxable income. Now that's going to be true for the U.S. computation, but it might or might not be true for Thailand. Maybe Thailand has a rule in its tax law that says that if a person is provided by his employer housing, it will be exempt, or it will be taxed at a reduced rate. A lot of countries have this. Japan has it. Again, this is a very, very interesting area, but it's a very complicated area because each time you're looking at potentially different countries, what their rules are, what are the policies of the company with respect to what the person is going to get or not get, how is each item defined, will each item be taxable income in that country, in Thailand, will it be taxable and how in the United States? If it's an item in kind, how do you value it? If it's not in cash, I mean, it's a very fascinating and complicated area. It is a specialty in and of itself. Okay, I think we've talked, in a sense, enough about number 1 and number 3. For the employees who are going to the U.S., I think we set up to 9 months. Okay, there's one question is, well, for a training assignment, there's probably a certain type of visa. I'm not sure what that certain type of visa is, but there's probably a certain type of visa. When they get to the U.S., Section 7701B is the provision which defines whether they are U.S. residents or non-residents. And I apologize, it's been far too long since I've looked at it, but I think there's probably an exception in there for people under certain types of training visas, so they could still be non-resident. Now, if you find that he's a non-resident of the U.S., now we look back at our income from employment, because now we have a Thai person. Before we had a U.S. individual coming to Thailand. Now we have a Thai individual employed by a Thai company spending 9 months getting trained. And let's assume that, yes, you decide he's a non-resident under 7701B. Okay, now we read this the opposite. We now read, okay, salary derived by a resident of Thailand in respect of employment shall be taxable only in Thailand unless the employment's exercised in the United States. If so exercised, such remuneration may be taxed in the United States. Okay, that's the general rule. So, employee of X spending time in United States, paragraph 1 says United States can tax it. Paragraph 2, remuneration derived by a resident of Thailand in respect of employment exercised in the United States shall be taxable only in Thailand if. Okay, now you have a 183-day rule, which maybe you'll fail. But maybe you could assume one of your, for the purposes of your paper, maybe you assume that one of the people will be there less time and will need that. Yes. Remuneration paid by an employer who is not a resident of the United States. And then now the remuneration is not borne by a permanent establishment which the employer has in the United States. X does not have a permanent establishment in the United States. So if you have a Thai guy who, doesn't fail because of the 183-day test, that Thai guy spending time in the United States. So he will be exempt from U.S. tax. He will only be taxable by Thailand. Again, if you have this guy who's there 9 months, well, how is the U.S. going to tax him? He's a non-resident of the U.S. How does the U.S. tax a non-resident who spends 9 months in the United States on training assignment? I assume, again, I have not looked any time recently, but I assume in 871, code section dealing with taxation of non-resident aliens, you can look and see whether there's any exception for people on training visas. Let's check. Okay, the OECD model has a payment with respect to students or business apprentice. Again, look at the Thai-US treaty. Maybe there's a provision that would apply to these guys who are trainees. Now, even if the domestic law is Section 871 taxes them, maybe there's a provision in the treaty which will cover this kind of thing, where a business apprentice who immediately before visiting the United States was a resident of Thailand and who is present in the United States solely for purposes of his education or training, received for the purpose of his maintenance, education, or training, that amount shall not be taxed in the United States, provided that such payments are from a source outside the United States. Maybe that provision, if there is one in the Thai-US treaty, but in a sense, the complexities never end. I mean, this is just the name of the game, and it's like a big jigsaw puzzle. So if you think about it that way, and you take pleasure in jigsaw puzzles, then this is a good profession for you. So we've talked some about these 3 categories, and there's, I'm sure, more we could say, but the individual area is a very, very interesting area.